right, everyone, it's now 2 p.m. It's time to get started. Ms. Champion, if you would let my secondary device into the Zoom conference, I would appreciate it. Is everyone able to hear me?
Yes.
All right, let's get
Yes,
started.
ma'am.
Is the jail on the screen? I see courtroom 2. All right.
We're ready.
All right, good afternoon. This is the state expedited accusations calendar. This calendar is for those individuals who have been recently arrested, but the cases have already been formally accused and found over to state court. All participants in this particular proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch this. All defendants, I see them coming in now. All defendants, please pay attention to these rights. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney at this proceeding today. When I ask you later about the rights, those are the rights to which I am referring. Are there any announcements from either the state or the defense before we begin?
Good afternoon, Your Honor. I am requesting a breakout for position number 6, and I submitted a waiver of appearance for position number 5.
All right, thank you, Ms. Gantt.
And Your Honor, state would object to a breakout on position number 6 unless it's for MHET.
It is for MHET, Your Honor.
All right. One other question before we begin. Ms. Champion or Ms. Strong, what is my SAP reset date?
The reset date will be December 1st, Your Honor.
Thank you. All those who receive a surety or a cash bond today will be reset to myself on the SAP calendar on December the 1st. Those who receive a signature bond either through the jail or pretrial will be reset for the notice. All right, who do we have first?
Good afternoon, Judge. This is going to be position 1, Anderson.
All right, good afternoon, Ms. Anderson. Your case is 22 CR 007861C. In that case, you're charged with criminal trespass with the offense date of November the 6th. You understand your rights?
Yes, ma'am.
All right, Mr. Howard, can I have that history, please?
This is a 4th arrest. Last was 2019, driving without a valid license. 2017, probation. Underlying charge was marijuana possession. And 2016, marijuana conviction. That's it.
All right, thank you. Is this your case, Ms. Dowry?
Yes, Your Honor, it is.
All right, please proceed.
Yes, Your Honor, this incident took place at 1000 Logistics Center Drive in Fairburn, Georgia. Officers responded and spoke with the victim, whose name is Jasmine, last name SHROPSHIRE. The victim informed officers that there was damage done to her vehicle, specifically that the defendant keyed her vehicle, which was a 2017 Toyota Camry. These acts did take place on video, so there is footage. Your Honor, the state's recommendation in this case is a $1,000 surety bond, no contact with the victim, 1-day anger awareness, no drugs, alcohol, or weapons. And Your Honor, the victim is on the Zoom call if you would like to sign for her.
All right, I will sign for her at the end. That is the criminal trespass. Is this your case, Ms. Gantt?
Yes, Your Honor.
Ms. Gantt, please proceed.
Thank you, Your Honor. Ms. Katrina Anderson is 25 years old. She has been in the Atlanta, Georgia area her entire life. She has family here, including her mother, a grandmother, and siblings. She also is the primary caretaker of a 3-year-old daughter, and she is not receiving any child support. Ms. Anderson completed high school, and she is currently employed at Materials in Motion. She has been on that job for about 3 months, Your Honor. We are strongly denying the allegations. The defense has not had the opportunity to view any video. Regarding my client's history, it appears that her last contact with law enforcement in the courts is 2019. She does not have any convictions for any similar offenses. Certainly, she is presumed innocent. She's recommended for a signature bond, therefore I'm requesting a signature bond on her behalf. We are asking for a no violent contact order, Your Honor, it is my understanding that, according to Ms. Anderson, she and the complaining witness, Ms. Shropshire, work in the same building. My client works in the warehouse and Ms. Shropshire works in a different room, so that they may have the occasion to see each other. So I would ask for a no violent contact so as to protect my client's interest in maintaining her employment. Thank you, Your Honor.
All right, thank you, Ms. Shropshire. At this time, I am going to sound for you. If you'd like to make a statement, I need you to turn on your camera. And before you begin speaking, I'll need to place you under oath. Do you wish to make a statement today? You are not required to do so. We'll give you a few moments to figure that out, but we must keep this proceeding moving.
I'm sorry, Your Honor, I was trying to unmute myself.
All right, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
I do.
All right, you can put your hand down. What the court is most concerned with at this time is whether you wish to have contact with this defendant. Please proceed with what you'd like to tell me.
I do not. I've actually tried to put a restraining order out on her about a few months back in February.
Objection, Your Honor, it's relevance. We are here on a totally different matter.
And Your Honor, she's speaking to.
I'll let her continue. Please continue, Ms. Shropshire.
Yes, ma'am. Like I said, I tried to put a restraining order out against her in February. They were unable to contact her to serve her the restraining order, so it didn't go through. So I would like to try to get one now if I could, because clearly it's continuing. So.
All right, we won't address that part today, but I do appreciate you making that statement. At this time, Ms. Anderson is going to receive a $2,000 signature bond through pretrial services. She's to have no contact whatsoever with the alleged victim in this case. If she sees her, she should turn around and go in the other direction. She's to complete the one-day anger awareness course and have no alcohol, drugs, or weapons as the condition of that signature bond through pretrial. Is there anything further from either party?
Yeah, what is the bond amount, 2,000 or 3,000?
2,000 through pretrial.
Thank you, Your Honor.
All right, best of luck to you, Ms. Anderson. Who do we have next?
Position 9, Price.
All right, good afternoon, Ms. Price. Your case number is 22 CR 00785 In this case, you're charged with criminal trespass with the offense date of November the 16th, and you're also charged with 1 count of willful obstruction. Do you understand your rights today? Do you understand your rights? You have a right to remain silent. Thank you. All right, Mr. Howard, can I have her history as well?
13 total. Last arrest was in August, failure to appear. Got an open shoplifting in Fulton County on probation for ag assault, 20 SC 176351. I got 4 years, 6 months probation for that in 2020. August probation, 2021 failure to appear, shoplifting, ag assault. 2019, 4 counts of shoplifting. That just shows as an arrest. 2018 trespass, simple assault, possession of drug-related objects, shoplifting. The shoplifting was a conviction. The possession was dismissed. Another 2018 shoplifting, another 2018 shoplifting.
That's sufficient. Thank you, Mr. Howard. I appreciate that. All right, is this your case, Ms. Backus? You're muted.
Yes, Your Honor.
All right, please proceed, Ms. Backus.
Your Honor, this incident occurred on the 16th of this month. Officers were patrolling the 600 block of Cascade Avenue when they observed the defendant standing against the wall of a building. It is the Red Carpet Liquor Store located at 687 Cascade Avenue Southwest. The defendant was trespassed from the store, and officers have received a 911 call about her earlier in the day, but by the time they got to the location, she had already left. So at this point, the officers got out of their car, advised the defendant to come to them, but she began walking away and screaming, "I don't want to go to jail." They continued to give her numerous commands, and she did not comply. Instead, she walked across the street. They finally caught up to her, tried to place her under arrest, and she tried to physically resist by pulling away from them. And after a brief struggle, they were finally able to get her into cuffs. Your Honor, the state on this case is asking for a $1,000 surety bond. My apologies, my email just covered it up. 500 on each count, and a stay away from that incident location of 687 Cascade Avenue Southwest.
Thank you, Ms. Mathis. Ms. Kim, please proceed.
Yes, Your Honor. Ms. Price is 26 years old, Your Honor. She has one minor child who is only 5 years old, who needs a lot of her attention. She has been unemployed for the last 2 years, and she's been trying to get disability check, and she has not been able to get it yet. However, she applied for her disability and she hopes to get it soon so she can make a living. She cleans up here and there for different kinds of trashes and things like that. Her highest education is 10th grade at this point. And Your Honor, she was actually standing against the building. She was not actually entering into the building. So we would like to request for a signature on bond and this criminal trespass to be dismissed. And also the other one is she is residentially challenged at this point. So we would like to request for definitely signature on bond since she has no financial resources. And I am requesting social worker services to help her with housing resources. Thank you.
All right, at this time, defendant will receive $1,000 split bond. It's going to be a $500 signature bond through the jail for count 1 and a $500 surety for count 2. And she must absolutely stay away from that location on Cascade Avenue, have no alcohol, drugs, or weapons as a condition. Is there anything further from either party?
Nothing
Nothing
further. Thank you, Your Honor.
All right, best of luck to you. Who do we have next?
14 West.
All right, good afternoon, Mr. West. Your case is 22 CR 007858C. You're charged with 1 count of obstruction and 1 count of possession of marijuana less than an ounce with the offense date of November the 17th. Do you understand your rights today?
Good afternoon. Yes, ma'am.
All right, thank you. Good afternoon. Mr. Howard, can I have the history?
24 total. Last arrest was in July for ag assault, simple battery, family violence. That appears to be open in Clayton County. On probation in the cab for battery DV. Back in April, they gave him 24 months probation for that. Also, public drunk, simple battery, criminal trespass in Fulton. That's open. 21 CR 003-568C. July 2021, simple assault, trespass. 2021, trespass, disorderly conduct, obstruction, misdemeanor possession of marijuana, disorderly conduct conviction from 2020. Yeah, that in simple battery. 2019 simple battery arrest. 2019 affray, and 08 robbery conviction. Terroristic threats, 2 counts, 1 count ag assault.
That's sufficient. If that's the past thing, yes. Thank you, Mr. Howard. Ms. Backes, please proceed.
Yes, Your Honor. This incident occurred yesterday. A MARTA officer was on a MARTA train, my apologies, when he saw the defendant smoking on the train, approached, asked the defendant to hand over what he was smoking, which the officer ascertained was, it was a blunt, but said it had a leafy green substance in it. The defendant then proceeded to throw it off the train, was successful in doing so. And so the officer proceeded to arrest the defendant, and he resisted by pulling away, but was eventually taken into custody. The state is asking for a $2,000 surety bond, $1,000 on each count, and to comply with any active MARTA suspensions, if there are any in place, Your Honor. Based on the history and the open cases, that is why the state would ask, in addition to, my apology, the open probation as well, we would ask that the surety bond would be put in place as opposed to a signature bond. Nothing further.
Great. Thank you. All right, Ms. Kim, please proceed.
Yes. Mr. Kevin West is 36 years old, and he has been here in Georgia for the last 33 years. He has actually one child that he's expecting. I mean, he, not himself, but his girlfriend is having a baby who is on the way. He does not have any job. However, he's trying to get detailing done for the cars to make some money. His education is up to 10th grade in high school, and he has a GED. He really has to take care of the expecting mother, who is also very, very sick as well. She's got some chronic disease that he has to take care of. We would like to request for signature on bond. They are staying at shelter for the residentially challenged people. So I'm going to see if there's any other housing resources available for them. And we would like to request for signature on bond for these charges. Thank you.
All right, at this time, the defendant will receive a $2,000 split bond, 1,000 surety bond on the obstruction, and 1,000 signature through the jail for the possession of the marijuana. He is to absolutely comply with any active MARTA suspensions and have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further. Thank you, Your Honor.
I would like,
Nothing further. Thank you.
Mr. West, I understand you want to say something. The best thing for you to do is to speak with Ms. Kim so that you don't infringe upon your right to remain silent. You may accidentally incriminate yourself, all right? So why don't you give Ms. Kim a call at the end of this proceeding, okay? If you have a limited question about the bond, I will hear it.
so what do I have to do with my brother?
Oh, Ms. Kim will explain that to you, all right?
Okay.
All right. Thank you.
Position 12, Walker. Right.
All right, good afternoon, Mr. Walker. Your case is 22 CR 007856G. In this case, you're charged with simple battery family violence with the offense date of November the 17th. You understand your rights?
Yes, ma'am. Good afternoon.
Good afternoon, Mr. Howard. Can I have the history?
This fifth arrest, he don't have any violence. All he has is marijuana charges.
Okay, thank you. That's good. Ms. Backus, please proceed.
Yes, Your Honor. Yesterday, officers were dispatched to an assault call. Upon arrival, they spoke with the caller, who's also the victim, LaTanya Harris, who stated that she was physically assaulted by her child's father, who's the defendant. She said that she was on the way to pick up her daughter from school, elementary school, and on the way there, she received a phone call. And it was the defendant. He said he had already picked up Aaron from school, but he did not have permission to do so. So she told him to take her back to the school. They ended up meeting at the intersection of Princeton Avenue and Atlanta Street. Ms. Harris said that she then asked the defendant to put Aaron in the back seat. They were arguing as he placed her in the seat, and she told him that he was never going to see his child again. That's when he walked up to the driver's side door, struck her in the back of the head, and then he fled the scene shortly after that. When the officer spoke with him, he gave a very similar story, except to say that he did swing towards the seat, but he hit the seat and missed her head. Your Honor, we are aware that that he doesn't have any violence in his history. However, based on the nature of the occurrence and in front of the young daughter, the state would be requesting a surety bond, $2,000 surety, no further contact with LaTanya Harris, a one-day anger awareness, stay away from the College Park Elementary school unless he has permission or prearrangements to be able to retrieve his daughter.
All right. All right, thank you. Before I go to Ms. Kim, I am going to sound for Ms. Harris. If Ms. Harris is on the Zoom conference and wishes to make a statement. Ms. Harris, if you're here. All right, hearing none, Ms. Kim.
Yes, Your Honor, Mr. Mario Walker, his side of story is different from what the warrant said, or even what she said, Your Honor. There was no physical violence. And when I was hearing his personal stories, that is very, very painful and I am just really impressed by how he conducted and handled this matter in a very professional and good manner, actually. I mean, there was no violence whatsoever, and it was her who was actually kidnapping their child. That child is a child of both Mr. Walker and the complaining witness, and he has a right to see his child. He has been supporting them for the last 7 years. It is the other person who's betraying this relationship. Mr. Walker has been here for more than 35 years, all his life, and he has only one child that he could not been able to see because the mother was kind of like being really unreasonable for him to see. Anyway, he has a job, 2 jobs that he's been working for the last 7 years, working really, really hard to support both complaining witness and a child. Even though somebody was totally not faithful, he has been faithful. He has been really good father. He has been good provider. He has a high school diploma, and there was no violence in history. Your Honor, I would like to request for signature on bond, and I think he is qualified. Thank you.
All right, at this time, the defendant is going to receive a $4,000 signature bond for pre-trial. He is to take the one-day anger awareness course. He's to have no contact with Ms. Harris. He can arrange transport of the child through a third party. He's to have no alcohol, drugs, or weapons, and he must comply with any orders that currently govern visitation and custody. Is there anything further from either party?
Nothing further, Your Honor. Thank you.
All right, best of luck to you, sir. Who do we have next?
11, Shannon.
All right, good afternoon, Mr. Shannon. Your case number is 22 CR 007859Y. In this case, you're charged with simple assault with the offense date of November the 17th of 2022. Do you understand your rights?
I do.
All right, thank you. Mr. Howard, can I have his history, please?
Second arrest, 2013 FTA for battery. It was NOD.
All right, thank you. Ms. Backus.
Yes, Your Honor. This incident occurred yesterday. An officer was dispatched to 1700 Northside Drive. On a dispute call. Upon arrival, he was met by the defendant, who stated that he had parked his car in the parking garage and the apartment complex put a boot on his car. And so the officer went in the leasing office, spoke with the victim, who was Mrs. Shani Grayson. Shani is spelled Shanie. Grayson is Grayson. She said that the defendant came into the leasing office, started yelling at her that they had booted his car and damaged it. The officer did review the video footage, which shows him acting aggressively towards Ms. Grayson. He was in her face yelling and then charged at her after multiple requests to get out of her face. And she said that she was in fear for her safety. The officers then obviously went and placed the defendant under arrest. We are aware of the limited history, Your Honor. The state is amenable to a $3,000 signature bond through pretrial services, one-day anger awareness, no further contact with Shani Grayson, and to stay away from that incident location.
All right, thank you. I am going to sound for Ms. Grayson on the chance that Ms. Grayson is on this Zoom conference. All right, Ms. Kim, does the defense have any objection? I'm inclined to grant the state's recommendation and give them a signature bond through pretrial. Is there any objection or any other information you'd like to add?
Yes, Your Honor. Actually, I would like to announce that he's not qualified for public defender's service. So after today's bond hearing, he will probably have to hire a private attorney. And yet I would like to request for a signature bond through jail, only because we have not seen the video footage yet whatsoever. So I do not know exactly what happened. And yet from my interview with Mr. Shannon, who has a master's degree in business and finance, and who has been very professional for his career, who's been here for more than 21 years, it does not seem like he was the one who was aggressive. I think his car, which was more than $100,000, that was damaged by the management, they made a mistakes on his car, and yet they are, in a sense, he's the one who called the police to resolve this issue. However, it kind of turned around and became an attack to him. And I would like to request for a signature on bond through the jail. Thanks.
All right, I'm going to accept the state's recommendation. He will receive a $3,000 signature bond through pretrial services. Take the one-day anger awareness course. Have no contact with the alleged victim, last name Grayson, and stay away from the location on Northside Drive. Have no alcohol, drugs, or weapons as a condition of that signature bond through pretrial. Is there anything further from either party?
Your Honor, I would just ask that you would add the name of the apartment to the stay away, which is Berkeley Heights.
Your Honor, we would like to object to the stay away order because he has to go there for his job. There is an employee who resides there, and he works as a realty group owner, and they do have to do certain projects there. So we would like to ask for stay away except those legitimate business purpose.
Okay, I can consent to that. If he has a legitimate business purpose, his own business for being on the property, he can return there. Otherwise, he should stay away from that location. Does that address all concerns?
One thing to add, in addition to that, I provide transportation to those employees that live that property. So they do not have vehicles. And so when
okay, so if you're there for, I don't want you to say too much, Mr. Shannon. If you're there for working purposes, you can return to that location, but have no contact with Ms. Grayson. All right?
Thank you so much.
All right, I believe that concludes your case. Best of luck to you, Mr. Shannon. If you have other questions, please contact Ms. Clem. Yes.
Your Honor, I'm sorry. I do have to just give you clarification on this for the record, because according to the police report, he's actually staying on the property. So does he work there, or is he staying there? Because it says he was like staying with a friend in apartment 204.
Let's clarify that. Ms. Kim, I don't want him to answer as best we can.
I do not think so, Your Honor. He has two different locations. He's a homeowner with investment property. So there is an employee that he provides transportation for his project. However, he does not reside there full time.
Okay.
All right.
I don't live there at all. Those are what my employees live.
Don't say anything, Mr. Shannon. Just thank you. All right. So if he has a business purpose, he can return to that location. All right, I believe that takes care of all concerns. Best of luck to you, Mr. Shannon. Who do we have next?
Ward.
Did we say position 4?
13, Ward.
Oh, 13, Ward. Thank you.
You're welcome. He also has a visitor in the gallery.
All right. Good afternoon, Mr. Ward. Your case number is 22 CR 007855Y. In this case, you're charged with theft by taking with the offense date of August the 31st of 2022. You understand your rights?
Yes, ma'am.
All right, thank you. Mr. Howard? First arrest. All right, thank you. Ms. Backus?
Yes, Your Honor. This incident occurred on August 31st of this year. An officer responded to 2040 Blatant Circle in reference to a package theft call. On the scene, the officer met with the victim, Mr. Rictavious Morton. Rictavious is spelled Ricktavious, Morton, common spelling. who stated that his package was taken out of the carport by a male. The package was delivered to his home earlier that morning, and about 35 minutes later, the defendant walked up the driveway, took the package, and walked off. The package did contain a lash bag that was valued at approximately $97. The officer reviewed the video surveillance footage of that location that was provided by the victim, and it did show the defendant removing the package from the carport, and then he left with it. And Mr. Morton advised that he has known the defendant for about over 3 years. They were in a relationship. He has had some other issues with him at the same location, and he is asking that there be no contact and a stay away. And he also has not received the contents of the package back that were taken. The state is asking for a $2,000 signature bond through pretrial services. Stay away from that incident location. No further contact with Brictavious Morton, and a theft class. Nothing further, Your Honor.
All right, thank you, Ms. Backus. I'm gonna sound for Mr. Morton. Is that the visitor that's in the gallery? I don't
I
believe so.
believe visitor is his mother. My client is 18 years old and his mother is there.
Okay.
I believe he said he did not want to attend the Zoom, Your Honor, so I don't believe he's on.
Fine. I'm still gonna.
That is the mother in the gallery.
All right, thank you. All right, we'll go to you, Ms. Kim.
Yes, Your Honor, Mr. Ward. We don't have any objection to signature on bond through a pretrial. Only thing is though the theft class, he is not guilty at this point and he's presumed to be innocent. And Your Honor, there was a relationship. He graduated from high school this May 2022. He's 18 years old. He's taking colonial art program at Atlanta Tech. He's also working part-time as a security and he was doing it for him. Anyway, Your Honor, we would like to request for everything same except theft class, Your Honor. Thank you.
Defendant will receive a $2,000 signature bond through pretrial. He's gonna need a co-signer. What is his mother's name?
His mother's name is Johanna, I'm sorry, Johnetta Ward, W-A-R-D.
All right, and I'll waive the utility bill. He
you.
is to have no further contact with the alleged victim, and he must absolutely stay away from that location. He is to have no alcohol, drugs, or weapons consistent with this bond ruling. Is there anything further?
Nothing further, Your Honor.
Francois,
Yes.
you can send the mother to the pretrial trailer. I'll call over there and tell them she's coming. She does
Okay.
have valid ID, right?
You have valid ID now? Yes, she does.
All right. Thank you.
All right, best of luck to you, Mr. Ward. We do not want to see you back here again, okay? Who do we have next?
Position 6, Foster. Come on, Foster. Have a seat.
Okay, can we do this case last? I believe this is the breakout case.
Oh, yes, if it's the breakout, yeah, we can do that.
Then we do that.
Position 10, Richardson.
All right, good afternoon, Mr. Richardson. Your case number is 22 CR 007857D. In this case, you're charged with 1 count of DUI with the offense date of November the 17th. Do you understand your rights?
Yes.
All right, Mr. Howard.
Fourth arrest. Last arrest was 2021 in Miami for smoking marijuana. Before that was 2009 DUI. It was amended. Before that was another DUI from 07 that was dismissed. That's all.
All right, thank you.
Your Honor, I would just like to quickly, so the GCIC does say that the 2007 DUI was dismissed, but the driving record shows it as a conviction. I was unable to get someone for driver services on the phone, but I just wanted to note that difference. This incident occurred yesterday. Officers responded to a call of a person stopped in traffic, and the driver appeared to be asleep at the wheel. The caller stated that the driver had sit through multiple cycles of a traffic light. The officers then spoke with the driver, also the defendant, who seemed to be confused about where he was, what was happening. So officers noted that he spoke with slurred speech and had watery eyes. So they asked him if he had had any alcohol that day. He said no. And then they asked him to get out, I believe to go to the ambulance, and he was observed walking in an unbalanced manner and using other vehicles to kind of keep his balance as he walked towards the ambulance. So officers found a vape pen, which they suspected contained THC, and then they later determined it to be Delta 8. They then searched the vehicle, found a bag that had 2 1-liter, 1.5-liter bottles of vodka in it. One was completely empty. The other was half full. And then they asked him again if he had been drinking, and he said, okay, a little. And then they asked him if he would do the standard field sobriety test. He said yes, and he had multiple signs of impairment, hence him being arrested for DUI less safe. Your Honor, just based on the fact that he had these 2 other DUIs, even though they're fairly remote. One was amended to a fingerprintable charge, but he's got the other conviction from 2007. The state would request a $5,000 surety bond that the defendant would report to the DUI court, and no alcohol, drugs, or weapons while out on bond.
All right, thank you, Ms. Kim.
Yes, Mr. Richardson is 43 years old, and he has been here in Georgia for the last 19 years. He has 2 children and his wife. His children are only 9 and 5, so he is the sole breadwinner for the family of 4, and he has been working as a chef for the last 15 years, and he graduated from high school, and also he has associate degree from college. And we would like to request for a very, very low bond, maximum of $1,000, Your Honor. The other DUI cases were very remote, Your Honor, and it was less safe. It was not a per se, and since he is not qualified for public defender's service, my representation will end at the end of this bond hearing. Thank you.
Your Honor, I do want to just briefly note, he doesn't, those DUIs are far back in time, but he also has some other driving offenses that are fairly recent. Within the last 5 years, he's got super speeders, speeding, and following too close. I think he had a total of 16 or 17 issues on his driving record as well. So just to add that to the record, Your Honor.
All right, thank you. At this time, the defendant will receive a $5,000 surety bond. He is to, within 3 days of his release, provide his information to DUI court. He is not to drive without a valid license issued by the Georgia DDS, and he is to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further, Your Honor. Thank you.
Nothing
All right.
further, Your Honor. Thank
Yes,
you.
I'll talk to you, Mr. Richardson. Who do we have next?
Position 8, McLean.
All right, good afternoon. Your case number is 22 CR 007868D. In this case, you're charged with 1 count of battery family violence and 1 count of cruelty to children in the 3rd degree, each with the offense date of November the 17th. You understand your rights?
Yes, ma'am.
All right, thank you. Mr. Howard?
11 total. Last arrest was in July. Possession of stolen mail, suspended license, suspended registration, no insurance. That's 22 CP 211068. On probation for theft by receiving, 16 SC 144445. Also on probation for burglary in the first and obstruction, 16 SC 145980. On probation for theft by receiving, 16 SC 146998. Got another theft by receiving, 19 SC 171512, and obstruction. That's it as far as the probation goes.
Right, thank you.
2019 probation violation. I don't think I saw any violent history. He got a shoplifting conviction from 2016 FTAs in his history. Yeah, I don't see any violence though.
Thank you. Ms. Lowry.
Yes, Your Honor. This incident actually took place on the road. The defendant and the victim, whose name is Cheyenne, that's Chyinna, last name Myers. She and the defendant and her son, whose initials are RM, they were riding in a vehicle when the defendant asked to see the victim's phone. When the victim refused, the defendant then began to punch her in the face. The victim's son was in the vehicle, so he did witness this incident. And once they were at their destination, the defendant hit the victim again, and this time he busted her lip. While he was swinging at the victim, he did, in fact, hit the victim's son. She had to defend herself by swinging a pocket knife at the defendant. Your Honor, this victim is also 7 months pregnant by the defendant. As we've heard from pretrial, the defendant does have a history that is predominantly thefts. However, he does present a risk of intimidating this victim. She's pregnant with his child, and he is a danger to the community. He's fighting her while he's driving. As such, Your Honor, the state's recommendation is a $6,000 surety bond. That's $4,000 on the battery family violence, $2,000 on the cruelty, no contact with the victim, to stay away from the victim's address, and I'll put that in the chat. No drugs, alcohol, or weapons. And Your Honor, I do believe she is on the Zoom.
All right, I'm gonna sound for Ms. Myers. Ms. Myers, if you're present on the Zoom conference and you wish to make a statement, I'm gonna ask that you turn on your camera at this time. You are not required to make a statement, however. All right, we'll go to Ms. Kent.
I'm sorry, Your Honor. We did speak with the victim. She did state that she wants no contact and for him to stay away.
All right, thank you. Ms. Kent?
Thank you, Your Honor. Mr. Sharkarius McLean is 23 years old. He has been in the Atlanta, Georgia area since 2014. He does have family here, including his mother and the one child that he shares with Ms. Myers. It is a 3-year-old. Your Honor, Mr. McLean he is currently enrolled at Atlanta Tech. He is studying biology. He also attended FAMU, but he has not graduated, Your Honor. Mr. McLean is currently employed at Capital Materials. He has only been working at that particular job for 2 months, so therefore he's still on probation. He's very concerned about losing his job. He strongly denies the allegations, Your Honor. He states that he was actually attacked first, and he was basically trying to calm her down, and that Ms. Myers has braces, and that is how she sustained the injury to her lip while he was trying to calm her down. He denies striking anyone, Your Honor. We do not have a long history of violence here. We actually do not have any convictions for violence. I am requesting a signature bond on Mr. McLean's behalf so that he may return to his job and defend against these allegations. He is not a risk of intimidating Ms. McLean, and of course he's presumed innocent, therefore he hasn't been convicted, so we can't say with certainty that he's a danger to the community based on allegations. We are unopposed to the no contact and the stay away orders, as my client does not wish to have contact. However, Your Honor, we are requesting third-party transfer so that Mr. McLean can continue to be involved in his child's life. Thank you, Your Honor.
All right, what's the age of the child?
3 years old.
All right. All right, at this time, the defendant will receive a $4,500 surety bond, $3,000 count 1, $1,500 count 2. He's to have no contact at all with the alleged victim, last name Myers. He can arrange third-party transport of the child through a third party. That does make sense. And he is to have no alcohol, drugs, or weapons. Before I make this decision, I apologize. The allegations are that the child RM is the one that was struck, and that is his own child?
I believe from what I read, Your Honor, that it is Ms. Myers' son and not my client's child.
That's
they have-
correct, Your Honor. She's pregnant with his child. She's currently.
Okay. She's pregnant with his child, but the 3-year-old that we would be transporting is not his child?
My understanding is that it is his child. Mr. McLean, is that correct?
No, ma'am, that's not my child. I was just taking care of that day.
Okay, all right. Well,
Okay.
then I apologize, Your Honor.
Okay,
I
so we will,
did not have.
right, that's okay, Ms. Gann, that's fine. So we were gonna delete that third-party transport part. He's to have no contact with Ms. Myers or the minor child RM at this time. He's to have no alcohol, drugs, or weapons as a condition. And he must stay away from that location. Is there anything, stay away from the victim's address? Is there anything further?
Nothing further, Your Honor.
Nothing
All
from
right.
the defense. Thank you, Your Honor.
Best of luck to you, sir.
I'll give you a call at the jail, Mr. McLean. Answer any questions you have. Thank you.
7 Jones.
All right, good afternoon, Mr. Jones. Your case number is 22 CR 007862G. In this case, you're charged with making harassing communications in August the 13th of 2019. Do you understand your rights?
Yes, ma'am, I'm doing that. Good afternoon.
All right, good afternoon. Mr. Howard, can I have his history?
13 total. Last arrest was in October, FTA for terrorist threats, trespass, and simple assault. That was out of the cab. 2018, he was initially arrested for those charges. 2014, probation. 2013, probation. 2006, probation. He had an ag assault for one of those probations out of the cab in 05. I saw an 01 robbery arrest. That's it. He does have bench warrants too.
Okay. Were those mentioned in the history?
No, it's on the booking. Ag assault, strangulation, burglary in the first degree.
All right.
I'll
thank you.
find out if he went to bench warrant court earlier and find out what happened. I'll be back though.
Thank you. Mr. Howard?
Yes, Your Honor. This incident took place via phone. However, the victim was at her home when she received calls from the defendant. The victim, her name is Kiara Thomas. That's Kiara. Thomas, common spelling. She and the defendant were in a relationship, but they were broken up at this point. That ag assault, strangulation, cruelty, and burglary charge, that was against this very same victim, and that was the reason they were no longer dating. However, the defendant continued to contact the victim, sending her numerous text messages, calling her. In this situation, officers did respond to the victim's home, and they saw that the defendant was actively calling the victim. They told her to put the call on speakerphone, and they heard the defendant telling the victim that whoever the guy was that was at her home needed to come out and he wanted to fight him. However, there was no one in the home except the victim and the police. So that's why we have this case today, Your Honor. The state's recommendation is a $3,000 surety bond, no contact with the victim, to stay away from the victim's address, 1-day anger awareness, no drugs, alcohol, or weapons. And Your Honor, that is the state's recommendation considering the FTA out of the cab from 2022 and the 2019 ag assault strangulation against the very same victim we have today. Nothing further.
All right, thank you. Mr. Lynch, is this your client?
Yes, Your Honor.
All right, please proceed.
Your Honor, Mr. Jones is 46 years old. He has been in Atlanta his entire life. He does work full-time as a security officer at Kroger. That's his full-time job at this point. He does have 2 children that he does co-parent and financially support. He's got a 13-year-old daughter and I believe a 15-year-old son. We are asking that you set a reasonable bond in this case, Your Honor. If you determine he's not eligible for a signature bond, we would ask that it be in an amount he can make. We would request that it be less than $3,000, perhaps $2,000 surety bond rather than the $3,000 bond. Just he only has his mother, his only source of support that could possibly help him make that bond. So we're just asking that you set it at that amount so he can possibly make the bond. He does contest these charges at this point, and so that's what we're asking.
All right, Ms. Sarah, what was that incident location? I apologize, or did you shout it to me?
Yes, Your Honor. 1 second. It was 4701 Flat Shows Road.
All right, thank you. This time, defendant will receive a $1,500 surety bond. He's to have no contact. Let me sound for Ms. Thomas. I don't believe I saw her. Is there Kiara Thomas present on the Zoom conference who wishes to make a statement? All right, hearing none. The defendant will receive a $1,500 surety bond. He's to have no contact with Ms. Kiara Thomas. He is to stay away from the address on Flat Shoals Road. He is to have no alcohol, drugs, or weapons as a condition of that surety bond. Is there anything further?
Nothing further, Judge.
This
All right.
time, no.
All right, best of luck to you, sir. Who do we
Your
have next?
Honor,
Yes,
Four, Dixon.
Your Honor.
yes, Ms. Gant.
I do apologize for interrupting. I wanted to bring to the court's attention while Mr. McLean, position aide, is still in the office. Your Honor, would ask for third-party transfer so that when his child is born, he may be able to see his child with the understanding that he is not to be around her during the birth.
Yes.
I'm gonna leave the order as is at this point, Ms. Gant. That contact can be revisited as that baby is not yet here. So I'll
you,
leave
Your Honor.
that at this. time. All right, thank you.
Thank you.
Oh, okay. She said she's gonna keep it where it's at.
All right, what do we have next?
Position 4, Dixon. She's gonna keep it where it's at. She's not changing.
All right, good afternoon, Mr. Dixon. Your case is 22 CR 007863J. You're charged with 3 counts of reckless conduct in this case with the offense date of November the 16th. Do you understand your rights? Oh, he's muted in courtroom too. All right, thank you. Hearing as how this is his first arrest, we'll go straight to Ms. Sowry.
Yes, Your Honor. This incident took place at 1099 Boulevard Southeast in Atlanta. The defendant was texted by a neighbor to inform him that there were 3 individuals actively breaking into his car. The individuals, their names are Quantez Walker, Franchot, that's FRANCHOT, last name PERSAUD. And the third individual is Cortez Ragland, that's KORTEZRAGLAND. Given this information, the defendant retrieved a firearm and shot at the cross defendants. One of the defendants, Mr. Walker, he was struck by a bullet. Your Honor, the state does understand that the defendant does not have a history. However, he does pose a significant risk to the community given these allegations. He shot a firearm at the individuals. He could have shot and hit anyone that was walking by. And shooting at someone for breaking into your car, it is not a justifiable use of force, Your Honor. As such, the state's recommendation is a $30,000 surety bond. That's $10,000 on each count, no contact with those cross defendants, and no drugs, alcohol, or weapons. Nothing further, Judge.
All right, thank you. Mr. Lynch, is this your client?
Yes, Your Honor. So Mr. Dixon is 22 years old. I believe he has a very limited, if any, criminal history. He does work full-time. He's a firefighter in Gwinnett County, from my understanding. He also does dialysis transport. He has lived in Atlanta his entire life. He does have a 2-year-old son who he financially supports and co-parents with the child's mother. Your Honor, I would ask that you take into consideration his active ties with the community and his lack of criminal history and set a bond that he can make, notwithstanding the seriousness of the allegations. Your Honor, we would just ask that if you you set a signature bond in his case due to his lack of history. He will comply with any terms of pretrial release. I've explained to him that he would need to check in. If Your Honor were to impose no firearms while out on bond, I'm sure that he can abide by that condition. But Your Honor, we would just ask that he be given the chance to contest these charges from outside of custody and explore his defenses in this case. So we would ask that you set a signature bond in this case. And if not, Your Honor, we'd ask that you set it in an amount that he has more of a chance to make, much lower than the $30,000 that was suggested by the state, Your Honor.
And Your Honor, given the nature of the case, the state would object to any signature bond.
All right, at this time, the defendant will receive a $30,000 signature bond through pretrial services. He is to surrender all firearms, weapons of any type, knives, guns, anything. Cannot have any weapons whatsoever. Is the Boulevard location is his home? Is that correct?
Yes, well, that's what I have, Your Honor.
All right, so we won't order that. Stay away. He's to have no contact with any of these cross defendants at this time. Is there anything further from either party?
Nothing further, Judge.
Not at this time.
All right, best of luck to you, Mr. Dixon. What do we have next?
3, Brown.
Your Honor, may I be excused?
Yes, you may. Have a great afternoon, Mr. Lane.
Thank you, Judge.
All right, Mr. Brown, your case number is 22 CR 007864C. In this case, you're charged with simple battery family violence with the offense date of June the 2nd. You understand your rights?
Good afternoon, yes, ma'am.
All right, please proceed, Mr. Howard.
His third arrest. He has a battery family violence out of Clayton County and a cruelty in the third. He got 12 months probation for that in 2019. It was first offender. Kidnapping, simple battery, DV, dismissed, false imprisonment out of Clayton County from 2017. He got a hold out of Gwinnett for assault. That's all.
All right, thank you. Sorry.
Yes, Your Honor. In this case, officers were dispatched to 55 Far Road Northeast regarding a dispute call. The victim in this case, whose name is Kiera Hall, that's K-I-E-R-R-A, Hall, common spelling. She informed officers that the defendant, who is the father of her child, the defendant and his girlfriend, approached her, and the defendant began to tell the other woman to attack the victim. She jumped on the victim. And Your Honor, as we've heard from pretrial, the defendant does have that 2019 battery. The state's recommendation in this case is a $4,000 surety bond with conditions of no contact with the victim, a third-party transfer of the minor child, stay away from the victim's address, and no drugs, alcohol, or weapons, and a one-day anger awareness. Nothing further.
I'm sorry. What was that amount?
It was a $4,000 surety.
All right, thank you. All right, Ms. Gant, please proceed.
Thank you, Your Honor. Marlon Brown is 28 years old. He has been in the Atlanta, Georgia area for 3 years. He has family here, including an uncle and a 1-year-old son. I'm sorry, his son is 4 years old. He has one son who is 4 years old that he shares with the complaining witness, Ms. Kiera Hall. He tells me, Your Honor, that this is totally made up. He strongly denies these allegations. He did not take another party to Ms. Hall. The warrant reflects that she filed this complaint the following day. He states that this is basically her attempt to get back at him for trying to get full custody of his child. He states that he has an attorney for that, and they have upcoming court dates so that he can gain full custody of his son. Your Honor, Mr. Brown completed high school. He attended Texas A&M and majored in sports management. He has a CDL license. He is he was employed as a truck driver. He reported for a new job just for one day, and then he was arrested. That is how he learned about this warrant, Your Honor. So he, may have lost his job that he recently secured. He was unemployed prior to that. He does not have the means to pay anything toward bond. And while I do acknowledge my client's history, the matter in 2019, he received first offender for that. The matter in Gwinnett, that is open. He's unaware of that warrant as well. So I am requesting a signature bond on Mr. Brown's behalf. If Your Honor determines that he is ineligible, then I would ask for a more reasonable bond, no more than $1,000. We are unopposed to any no contact and stay away provisions, and we would surely request third-party transfer, Your Honor. Thank you.
All right. At this time, the defendant's going to receive a $2,500 surety bond. Oh, I'm going to sound for Ms. Hall. Is Ms. Hall present on this Zoom conference and wishes to be heard? All right, hearing none. $2,500 surety bond. He's to have no contact with Ms. Hall and stay away from the incident location. He's to have no alcohol, drugs, or weapons. And as a reminder, he'll be reset to the SAP calendar on December the 1st.
Your Honor, what about third-party transfer? Did you mention that?
How old is the child?
The child is 4 years old.
All right, he can arrange to see his child by arranging transport through a third party.
Thank you, Your Honor.
All right, best of luck to you, sir. Who do we have next?
Thank you, Ron. God bless.
All right, who do we have next?
Position 2, Bald.
Good afternoon. Good afternoon, everyone.
Good afternoon, Mr. Bald. Your case number is 22 CR 007866F. You're charged with 4 counts of giving false information and 1 count of driving on an expired tag with the offense date of November the 17th. Do you understand your rights? All right, Mr. Howard.
21 total. Last arrest was May 2021, suspended license. Probation in the cab for ag battery. 2019, they gave him 3 years and 6 months for that. That was December 2019. Also on probation for simple assault out of Pennsylvania. I saw a speeding from 2017 out of South Carolina. Speeding and driving without a valid license conviction. The 2020 was Pennsylvania, the ag assault and criminal mischief. The ag assault portion was dismissed. History out of Virginia. Last arrest in Virginia was 2004. Violation of protection orders. 2018 out of state fugitive out of Florida. I see a couple of warrants too for his arrest. 1 out of Decatur. 2021 probation violation. 2021 another probation violation. 2019 one from 2018. 1 from 2017. Another one from 2017. 2015.
I think that's good. Thank you, Mr. Howard. Ms. Sowry.
Yes, Your Honor. In this case, officers ran the tag of the defendant's vehicle and it came back as no registration. When officers asked for the defendant's name, he gave a false name of, I'm sorry, 1 second. That false name was IMMURANA, last name Sheriff, and date of birth 5/4/1984. He then gave a second date of birth is 5/5/1985, and then a third date of birth that's 5/4/1983. As we know, this defendant's date of birth is not any of the 3 given, and his name is not the name that was given. As we've heard from pretrial, he does have driving offenses. He had a speeding conviction. He was going 55 and a 35. He's a multi-state offender, Your Honor, as well as the FTAs. The state is concerned regarding the ties to the community. The probation violations, we are concerned with those as well. As such, Your Honor, the state's recommendation is a $1,000 surety bond on each charge. That would be $5,000 total. No drugs, alcohol, or weapons while on bond. Nothing further.
All right, thank you, Ms. Sauer. Ms. Gant.
Thank you, Your Honor. Mr. Mamadou Baldy is 34 years old. He has been in the Atlanta, Georgia area for 12 years. He is married and has been so for 7 years. He is the proud father of a 3-week-old. Your Honor, he informs me that his wife experienced some postpartum complications while delivering his first child. She was never discharged from the hospital. He states that his family is going through a financial crisis at this time. And to just so that the court is aware that his light bill is due, and of course, he is at risk of not having any power in the home to help to ensure that that newborn is safe. Your Honor, Mr. Baldy completed high school. He earned a bachelor's in engineering. However, he is not working in that capacity. He states that he is employed in emergency medical services. He has been in that line of work for the past 2.5 years. He denies the allegations. He states that he had just purchased that car. Regarding my client's driving history, Your Honor, the matter in May of 2021 is resolved. These are driving offenses, Your Honor. The probation violations and probation are for different offenses. These are driving offenses, Your Honor, for the most part. I am requesting a signature bond on Mr. Baldy's behalf, as he does not have the means to pay anything toward bond, given the nature of the offenses and his remote history of driving offenses, Your Honor. Thank you.
All right, at this time, the defendant is going to receive a $1,250 split bond on each charge of giving a false information to an officer. It'll be a $250 surety bond. He's going to receive a $250 signature bond through the jail for the expired tag. And he is to have no alcohol, drugs, or weapon. Is there anything further from either party?
Nothing further, Your Honor.
Nothing from the defense. Thank you, Your Honor.
All right, best of luck to you, sir. Who do we have next? I believe the only one left is that breakout case.
Position 6 Boston. I'm sorry, Judge, we have a lot going on. Can you please repeat the bond?
It's a $1,250. The count 2 is going to be a signature through the jail, and each other remaining count is a $250 surety. He'll need to make 1,000 surety, and 250 is signed through the jail.
Thank you.
All right, thank you. Can we go into the breakout, please, for position 6?
Is number 5 still reset?
Number 5 is a waiver of appearance.
Okay.
Is my statement to be given to you, Judge, before the breakout or after the breakout? This is Councilwoman Mary Norwood.
Oh, good afternoon, Ms. Norwood. I'm sure in the breakout, Ms. Falk will make me aware of the substance. When we come back, we'll hear from you.
All right, thank you.
Thank you.
Thank you, Your Honor.
I'm sorry, Judge, who's supposed to be placed in the breakout room? Ms. Gant, who else?
Myself, Ms. Gant, Ms. Falk, I believe, will be it.
Yes.
Your Honor, this is Mr. Paulson.
before we begin with Mr. Foster's case, are there other inmates at courtroom 2 at this time, or is he alone?
No, he's by himself, Judge.
Okay, thank you. That was what the court was wondering. All right, Mr. Foster, your case number is 22 CR 007864C. I will not sound the charge at this time with the offense date of October the 8th of 2022. Do you understand your rights here today? I'm going to explain them again. You have a right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney at this proceeding. This proceeding is being broadcast over the internet. It is also being recorded. That means any member of the public can watch this proceeding. I have advised you of your rights. I will assume going forward that you do understand those. Ms. Falk, please proceed. Afterwards, we'll hear from Councilwoman Norwood.
Yes, Your Honor. As I had previously stated, this happened on October 8th of 2022. This defendant was observed in Loudermilk Park. He had removed all of his clothing and was standing in view of the public, smiling at vehicles passing by. This happened at approximately 1:50 p.m. So this was during the daytime, and according to the dates, it was on a Saturday. And so this defendant was, out there on a Saturday in a park where children, families, what have you, are passing by and can observe him. Additionally, according to information I have received and there were videotapes taken of this defendant since he is a repeat offender for this same type of offense. And my understanding is that he was also touching himself inappropriately. One of the things that I did want to address is that this is his 5th arrest for this type of offense. He was arrested March 24th and taken to municipal court under 22 CR 001802. He was then arrested on April 11th for the same offense and taken to municipal court under 22 CR 002282. On June 4th, he was arrested again for the same offense and given case number 22 CR 004416. That case was later dismissed by municipal court. Finally, he was arrested June 12th of this year, again on the same offense, where he was given case number 22 CR 003765. He pled to that charge here in state court on June 28th, received 12 months to serve with 12 days. And also received a stay away order from 3107 Peachtree Road, which is Loudermilk Park. The defendant continues to return back to this location, and on the previous March, April, and June cases, he also has FTAs out of municipal court. We are having those cases transferred over to state court to address because, as Your Honor knows, if he receives a second conviction, this will make the subsequent cases felonies. We are asking for a $10,000 surety bond. We are asking that he stay away with no exception from Loudermilk Park, and we are asking for an MHET in this case.
Yeah, I did.
All right. Thank you, Ms. Falk. Councilwoman Norwood, at this time, I'd like to hear from you. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
I do.
Thank you. Please proceed.
As the District 8 Councilwoman, I would like to submit the concerns of the citizens I represent. Mr. Markel Foster has been arrested on the charge of—
Objection, Your Honor. Objection, Your Honor. Relevance. Ms. Norwood is not a party to this case, Your Honor. And this is not a trial.
I'm gonna allow it. Please proceed, Ms. Norwood.
Mr. Foster has been arrested on a charge of public indecency. I would like to explain that his actions are more grievous than this charge would suggest. Mr. Foster was masturbating in public in Loudermilk Park on I understood, Sunday morning from the witnesses, and was seen by families, moms, dads, and children going home from church. This is not the first time that Mr. Foster has been masturbating in public. He has had 3 arrests, which as you have heard, have been heard in municipal court, and 1 arrest, which has been heard in state court. My constituents deserve to be able to take their children to church or to school or to shop or to go to a restaurant without the worry of exposing them to nudity and lewd behavior. It is my understanding that the city charges are being bound over to the state court, and that cannot happen soon enough. Please do whatever you can to prevent this individual from continuing to plague my community with his appalling behavior.
Thank you, Councilwoman Norwood. I appreciate you coming and making that statement. Ms. Gant, please proceed.
Again, Your Honor, I would object to this line of testimony. Again, Ms. Norwood is not a party to this case. My client is presumed innocent. These are allegations, and he is entitled to be heard. Just in terms of due process, Your Honor, Mr. Foster, we've expressed our concerns to the court in a breakout. He is 31 years old. He is a resident of Atlanta, residentially challenged. He does not have the means to make it bond. He does not have any family resources. He is residentially challenged. Again, we are denying the allegations on his behalf, Your Honor. He's presumed innocent. I would ask for a more reasonable bond, and we are unopposed to the MHET and the stay away conditions. Thank you, Your Honor.
All right, at this time, the defendant will receive an $8,000 surety bond. He's to undergo evaluations as discussed in the breakout. He is to have absolutely under no circumstances return to that park on Peachtree Road, the Loudermilk Park. And should he make bond, he is to have no alcohol, drugs, or weapons as a condition. He will be reset to the competency calendar on December the 1st, whereby myself will be appearing. Ms. Falk?
That's
Did
all.
you have other?
Thank you.
All right.
Nothing further.
All right. Best of luck to you, Mr. Foster. Is there anything further from either party? I do believe not. And I believe that's the conclusion of the
May I just say, Your Honor, and if this is out of order, I apologize. But we do have video. We do have evidence, which I can, of course, get to the court should you need it.
And again, Your Honor, the defense has not had the opportunity to view any evidence, and despite Ms. Norwood's position, my client is still entitled to due process, and he's presumed innocent.
Yes, Ms. Gann, I will not be reviewing any evidence today. I'm sure it will be provided to the court as required by the laws of evidence in the state of Georgia. All right. I set bond, and I believe that concludes all of our business. Ms. Champion, will you please review the entire calendar for us? Oh, we need to do the waiver case. I apologize. Courtroom 2 can be excused, however.
Thank you, Judge.
All right, take care. Have a great rest of your afternoon. Thank you, Ms. Norwood. You can also be excused unless you'd like to remain with us for the rest of the calendar. We'll now do the case of 22 CR 007845Y. The name, I believe, is Nadine Espada, in which the defendant is charged with battery family violence with the offense date of November the 15th. Mr. Howard, can I have that defendant's history, please?
This is 5th adult arrest. Last was 2013, theft by taking, battery, trespass, and battery DV. All those cases, all those charges were dismissed. 2011 probation. He was later convicted for misdemeanor possession of marijuana after giving first offender. 2009 theft by deception, that was dismissed. And the first cycle was his juvie arrest. That's it. He was recommended. I don't know why he didn't come to court though.
All right. Was this a medical reset, Ms. Gant?
Yes, Your Honor, he is in quarantine.
Okay. All right. Ms. Towery, please proceed.
Yes, Your Honor. This incident took place at 3390 Fairburn Road, Southwest in Atlanta. Officers were dispatched regarding a domestic dispute. There was actually a third party that called 911 in reference to the victim, whose name is Victoria Hazelwood. That's Hazelwood. That third party saw the victim with blood on her shirt, and the defendant was throwing items outside of an apartment. Upon arrival, the victim informed officers that she was being evicted from her home, where the defendant also lived with her, and that when she informed the defendant that she needed money to get another apartment, he got upset with her and started to punch her in the mouth. As such, Your Honor, the victim started to bleed, and then she bit the defendant out of self-defense, and that's when he started to throw items around the apartment. Your Honor, initially, this was a dual arrest case, but due to the state's evaluation of the facts, the fact that she had bruises, lacerations, the bloody mouth, and the third party's statements, the state has determined that the defendant was actually the primary aggressor, and we're charging him as such. The victim's charges were dismissed. Your Honor, he does present a risk of intimidating this victim, a risk of reoffending. She was on the Zoom call. I don't see her now. However, our office was able to get in contact with the victim. She stated that this was not the first time he has beat on her. As such, Your Honor, the state's recommendation is a $3,000 surety bond to stay away from the incident location, no contact with the victim, 1 day anger awareness, and no drugs, alcohol, or weapons. Nothing further.
All right, thank you. Ms. Kim?
Oh, it's my client, Your Honor.
Oh, I'm sorry. I saw Ms. Kim on the screen. Ms. Kim, before we begin, I'm sorry. Ms. Sauer, you did say she was on the line. Can you please give me the victim's name again?
She was on the line. I don't see her anymore, but her name is Victoria Hazelwood.
All right, Ms. Hazelwood, I am sounding for you now. In the event you are still here and would like to make a statement. All right, hearing none, please proceed, Ms. Gant.
Thank you, Your Honor. Mr. Naidan Espada is 33 years old. He has been in the Atlanta, Georgia area since 1996. He is the proud father of 4 children, ages 3, 5, 11, and 14. He does not share any children with the complaining witness, Ms. Hazelwood. Mr. Espada completed high school. He also has a bachelor's in business. He is currently employed at the Hampton and Hudson Bar and Grill. He has been in that position for 1 year. He strongly denies the allegations, and he certainly is presumed innocent. He does not, his last contact, of course, with the courts was back in 2013. We believe that is far too remote for the court to consider. He is recommended for a signature bond. I'm requesting a signature bond on Mr. Espada's behalf. We are unopposed to the no contact and the stay away orders, as my client does not want to have contact. However, Your Honor, we are requesting a one-time law enforcement escort so that Mr. Espada may retrieve his belongings from Ms. Hazelwood's residence, Your Honor. Thank you.
All right, at this time, defendant will receive a $6,000 signature bond through pretrial. He's to take the 1 day anger awareness course. He's to have no contact with the alleged victim and stay away from the incident location. He can return 1 time with a member of law enforcement to get any items. Otherwise, he must stay away. He's to have no alcohol, drugs, or weapons as a condition.
Right.
Is there anything further?
Nothing further from the state.
Nothing from the defense. Thank you, Your Honor.
All right, best of luck to that
He
defendant.
does
Please
speak
ex-
English, right?
Would he need an interpreter, Ms. Gant?
No, he speaks English.
Okay, cool. All right.
All right, can we review the calendar, please?
Right, position number 1 is a $2,000 pretrial bond reset for the notice. Position number 2 is a total of a $1,250 split bond reset SAP 12-1. Position number 3 is a $2,500 good bond reset SAP 12-1. Position number 4 is a total of a $30,000 pretrial bond reset for the notice. Position number 5 is a $6,000 pretrial bond reset for the notice. Position number 6 is the $8,000 good bond reset SAP competency calendar 12-1. Position number 7 is a $1,500 good bond reset SAP 12-1. Position number 8 is a total of a $4,500 good bond reset SAP 12-1. Position number 9 is a total of a $1,000 split bond reset SAP 12-1. Position number 10 is a $5,000 good bond reset SAP 12-1. Position number 11 is a $3,000 pretrial bond reset for the notice. Position number 12 is a $4,000 pretrial bond reset for the notice. Position number 13 is a $2,000 pretrial bond reset for the notice. And position number 14 is a total of a $2,000 split bond reset SAP 12-1. Any questions or concerns?
Yes. For number 2, how much is good and how much is SOB jail?
The SOB jail is expired tag the second charge and all the rest of it is a, good fund.
What's the amount?
$250.
It's 1,000
50
total.
each? Okay, thank you.
And if I may, is there a date that is scheduled for the next competency calendar?
It's the same date, that Thursday, December 1st is a Thursday, therefore there'll be SAP and competency. And
Thank
we'll
you.
just have him put on the competency that day.
Thank
All
you.
right. Hearing no other questions, comments, or changes, we will be in recess until tomorrow's SCA calendar at 2 o'clock. Everyone take care. Enjoy the rest of your afternoon. Bye-bye.
Thank you.